Good evening, everyone, and welcome to another edition of our Justice and Pieces guest speaker series. As we've been joined with various lawyers, paralegals, and others from the legal profession here to share about their practice and advice for newly licensed and students alike. Today, we're joined by Dante. So, Dante, first of all, thanks so much for joining us, and maybe you could tell us a little bit about yourself and your practice.
Thanks for having me, JP. My name's Dante Spadacini. I predominantly practice in real estate and estate law. Litigator by trade. Did some some appeal work, Court of Appeal, Divisional Court. A lot of small claims court work. Still have some ongoing small claims court files. But yeah, mostly focus on real estate and some teaching with you at Centennial College.
All right, so let's get started with the litigator by trade. So, maybe tell us a little bit about your old or current still litigation work, and certainly on the appeal front, that's something that our students don't have in their scope predominantly, right? How would you kind of get ready for an appeal, and how is it different than than the actual litigation to start the process with?
Yeah, it's definitely outside the scope of paralegals, but it does come up, right? It comes up a lot in landlord and tenant and small claims court courses because we touch on the next steps, right? And definitely you can appeal small claims court cases to the divisional court. It's like Ontario's first level of appeal court, and landlord and tenant matters, right? And most administrative tribunals, we have the opportunity, as long as we've exhausted all of the appeal procedures within that particular tribunal, we can go to the divisional court. So it always comes up when I'm lecturing about small claims and all those other tribunals and landlord and tenant, that we can go to the divisional court. However, it kind of ends there because paralegals are limited in scope when it comes to appeal work. Divisional court, Court of Appeal, it's something that you would have to refer to a lawyer, and specifically a lawyer that's geared to appeal work.
So, what do you find? I mean, in terms of doing appeal work, what's different there from the actual litigation in terms of preparation? So, let's pick a small claims file there that goes for appeal, or anything else that you might have been working on. How do you prepare differently with an appeal at the divisional court versus the initial matter?
Yeah, and that's what I explain to students too. It's a whole different beast, right? When we're dealing with civil matters, or even a criminal matter. With a civil matter, we're looking at facts. We're looking at law that pertains to a civil matter between two individuals. When we're appealing cases, and before I knew anything about the law, you would just think it was a second kick at the can, which, I mean, essentially it's not, right? You don't just get a second chance here. To appeal a small claims court matter, for instance, it would have to be on an error of law. So the court got it wrong. They applied the law wrong, and in limited circumstances, we can appeal these interim orders, right? So generally an appeal, divisional court, Court of Appeal, we're dealing with decisions that are final. So for small claims, a final decision, appeal to the divisional court without leave. As we say, we don't need permission from the court by right. There's some exceptions, and but for interim orders, certain motions that we have in small claims, the judge may have got it wrong, the deputy judge may have got it wrong, and a lawyer, at that time would want to appeal it to the divisional court, but it would be limited because it's only for a final order. But in limited circumstances, an interlocutory order or an interim order can be appealed based on jurisdiction and limited circumstances like that. So when you're preparing for an appeal, it's different because we're dealing with errors, right? And the case isn't heard on its merits, right? If we're dealing with a personal injury claim, for instance, somebody got punched in the face, right? I always use that example. You're suing for damages, medical, and otherwise. at trial, you're establishing the wrong, or you're establishing liability first, and then once you establish liability as a plaintiff, you're trying to establish what the damages are. An appeal, those things are already determined, right? So we're trying to get into where the judge made an error in that decision, right? Some procedural fairness error. It would depend on a specific circumstance. One appeal we have, I think it's actually still in the court right now. And we got a small claims court claim decision. Reading the decision, I can't make heads or tails, how the judge got to this decision. And I think I have a pretty good comprehension of understanding these things. And if I can't understand it, show my client they can't understand it, that means it's not a clear decision, right? So based on that alone, we need to receive decisions that we can understand and have reasons behind them, right? Because judges are judges, but they still have to give us reasons, and that's part of procedural fairness. So that would be a condition that I would consider when appealing. And so when you're preparing for that, you're preparing for the error the judge made, right? We're not going to the merits again. We're dealing with the error, and it's tricky. And even you go further, the Court of Appeal, where leave in some instances is required. So the court looks at your case and decides whether or not it's even something they're going to hear. There's a whole different test there, right? Leave, is it of public importance? Is it important to Ontario residents as a whole? Like the Supreme Court of Canada, same test, right? Is it something that concerns all of Canadians? It has nothing to do with the merits. It has nothing to do with the error, just to get in the door. So there's different things we have to establish, and same type of reasoning and breaking down the law, but we're looking at different properties and different case law for sure when we're dealing with appeal cases.
The other thing there, whether it's by appeal or judicial review, the standard of reasonableness, right? And certainly students are trying to grasp, how does this work, where they might say, hey, we don't necessarily agree with that decision, but it seems reasonable to us, so we're gonna to give it deference to the lower court or to the tribunal. How do you kind of sort of structure your arguments, arguing these errors of law or what have you, knowing that that's the standard and there's great deference? Is there anything you can do to highlight, to maybe get through that, though this error is unreasonable, rather than having them defer to the lower body there?
Yeah, well, you're right. I mean, the courts are always going to have deference, right? They're always going to, take the decision for what it is. But again, if procedural fairness is evident, and we can point that out, there's tests that are enshrined in precedent and case law, which our whole system is built on. You follow these tests, and if procedural fairness isn't followed, then you have yourself a case. It's not something that a judge is going to look at and make their decision on without looking at other case law, because again, they're following other cases. When we build cases, even in small claims, we're looking at the highest court in the land if we can get that. So it's the same thing with procedural fairness. You're looking at a test that's provided by the court. Hopefully you can find something as close to your matter on all fours, as we say, through the case law, and you're going to provide some kind of insight to what you need to establish, right? Just because we feel it's not fair, right, of course, isn't enough. If a student, well, that's not right, and I beg to differ, and I hear all of these things. The student, well, show me what's not fair, and look at the test, and if those elements are not there, then you don't have something that's not procedurally fair.
Now let's sort of switch there. I mean, you talked about being a litigator by trade, but now you're practicing a lot of real estate and estates. Are those litigation matters, or are there more sort of solicitor kind of work? And how do you kind of compare, from being in front of the Court of Appeal and making oral submissions to now doing sort of more solicitor work, and how do you kind of find a balance in doing a little bit of both there?
Well, yeah, I mean, there's a big difference, JP, with that. You know, so you're right. It's solicitor work. With real estate transactions, residential, commercial real estate transactions. Solicitor work. The transaction comes up. You do what you need to do to get the transaction done. There's no advocating in a court. You don't have to put on the robes. You don't have to do anything like that. But there's more oversight. There's a lot more liability, specifically with real estate transactions, as we see in the news. It's getting more and more common that individuals' homes are being sold without them knowing. Mortgages are being taken out on properties. So what's happened is the banks and I guess the government regulators have chosen a profession many years ago where we can trust and say, listen, you're going to take care of this. And there's not a lot of guidance. I tell you, you're not going to get a lot of questions answered when you're acting on behalf of a lender, because they're going to expect you to have the answers. They're going to tell you that here's the deal. If you mess up, it's on you, and just make sure everything's done right. In a residential real estate transaction, I tell my clients all the time, and I make sure I tell them this because they just don't know that, a standard home, you purchase a home, you get your mortgage. I act for my clients, the purchasers, but I'm acting for the lender as well. The lender, I act for the banks all the time, and we're in their system. They send us the deal, and we're basically their lawyer and the client's lawyer. And so what the bank is saying, you're there to make sure that everything's on the up and up, that they're who they say they are. You're going to do the identity checks. You're going to make sure the property, there's no encumbrances on the property according to whatever conditions they have in this mortgage. So you're acting for two individuals, and basically you're a watchdog where realistically, the bank should have their own lawyer that's dealing with this, right? So they get the best of both worlds, banks. So that compared to litigating and submissions at any level of court, it's just a little bit different. Stress wise, if when you're some individuals comes naturally to them. There's always that, the nerves that come in anytime you're making submissions at any level of court, in my opinion. The preparation's got to be done, and I always get my students, get it through them that, the work ethic of being over prepared, then you don't have to worry about anything. As soon as you're not over prepared, then you get to a point where that's what's going to come up, and it always gets you, right? So the preparation's the same with advocating at court, or I'm doing transactional work. It's just the showtime, right? It's like teaching, advocating. You have an audience, right? And you're there, and everybody's got their eyes on you, and you have to perform, right? And solicitor work you can kind of do behind the scenes, make sure everything's okay. It's like baking a cake, really. You put everything together, and the transaction closes on that date, and it's done. With litigating, it's fluid. You can move around, you can schedule your own dates, you can amend things, this and that. If you do a real estate deal wrong, you got to redo things once it's closed. It's a little bit more stressful in that sense, but I think that the going in front of a panel, having all of your arguments, being prepared for the questions you're going to be asked, right? You're going to be drilled, especially at the Court of Appeal, right? You're sitting there, and there's a panel, and if you ever watch on C-SPAN, right? Just in the middle of argument, okay, hang on a second, I want some clarification here. Throw you right off. It's not to throw you off; it's to get clarification, because that's why they're there. You got to be pretty good on your toes to do that. So it's a high stress game, and that's why I tell my students, if you want to advocate in small claims, you got to be quick on your feet. You got to be able to take notes and ensure that you know what's going on. So they're different in both ways. But with regards to me and teaching and making everything fit, transactional work helps a little bit. With organizing, if with teaching, it's litigation for me. It takes everything for some reason. It takes everything out of you, and it's just it's ongoing. You may have more than one file for sure, but it's just a different mindset, in my opinion. And because transaction, you do it, it's done, you move on to the next one. litigation, as we know, it drags on, and there's always something different, and it can be very aggressive too. That's the stressful part. It can be very aggressive, even though we're all professionals, lawyers and paralegals working with each other. We can get wake up to get that nasty email in the morning, and it just changes your day a little bit, right?
Yeah, and I think certainly not necessarily for our paralegal students, but any law students that are going into or getting called and wanting to do real estate or estates work or more solicitor based work, maybe they say that's more of my personality, right? In terms of doing and being looking over things with a fine tooth comb there. But any tips there for anyone that's going to get, they as you point out, a lot of the banks are expecting you to know things. And if you're starting out, you may not necessarily know them, and certainly you can go and find other real estate lawyers as mentors. But especially, you mentioned that there's a lot of fraud that people are trying to take advantage of. They're renting the house, but they portray themselves as the owner, and if you didn't check over the ID, or suddenly they're saying, hey, deposit in this account. What are some of those red flags that we learn in terms of our rules of professional conduct, and making sure we don't get duped by these fraudsters that especially given that there's millions of dollars in mortgages being funded, right? That we don't want to come across having a big complaint to the law society and our insurance going through the roof because we just didn't notice that the bank that we're depositing in is slightly different than the one that the client first gave us.
Well, yeah, I mean, there's a lot of resources out there, and of course, the first thing you said, mentors, colleagues, if any, like you say, if any law students are waiting to be called and they articled anywhere, that's your resource, right? In that helps, but that's not everything. If you work at a big firm, that's a benefit of working a big law, right? You can walk down the hall, you have some support. Sole practitioners, I talk about sole practitioners a lot, when we're teaching our students in the paralegal program, because there's a good chance that some of them want to go ahead and start out on their own. So the Law Society has a lot of resources for, specifically, we were talking about these types of transactions that you got to be very careful, because the last thing you want is to get duped, as you say, right? And that's a thing, right? That's a term that we use. Lawyers and paralegals get duped. Law Pro, our governing insurance provider, they have a lot of resources for fraud, because it's in their best interest to ensure they don't have all these claims on their hand. But red flags, and it's interesting that you asked that, because I'm always asking and looking for red flags, because as we see with even telemarketer scams, or auto thefts, they're always a step ahead, and we need to know these new things that they're doing, right? One thing that I make sure I do, and it's kind of a known thing in the real estate practice, but if you don't know, this is a very helpful one, and I'd be surprised if you're practicing you don't know. It's call before you click. So part of a real estate transaction, imagine we're selling a property for a client, and when we're selling a property, we're clearing of any encumbrances unless it's agreed upon, but generally no mortgages would be on property. So, you're selling a residential property. It had, we search title, we talk to our client. There's a $200,000 mortgage from RBC, which was their original mortgage. We have to pay that mortgage out on the closing of the transaction, because the new purchaser doesn't want that on title. So we ask RBC for what we call a payout statement. They send us a statement. We tell them when the transaction's closing, right? June 13th, transaction's closing. They give us a payout statement on that date with the principal, interest, per diem. You pay this on this day, you're good. We get the amount. We sell the property. From the proceeds, we pay out the mortgage. But the key is that statement. You need to call and ensure that the information, because we're getting information to an account where to deposit these funds, and usually by direct deposit through a bank, through a draft or a certified check. We don't do a lot of wires for this reason. But you're calling to confirm, right? Because what the fraudsters are doing is they're intercepting our emails. And I'm getting an email with a payout statement. I mean, the big banks, not so much. Maybe the unknown banks that are not really familiar with the mainstream. There's a lot of not even B lenders, but they're A lenders, like MPAC and Computer Share, that we don't really hear, but real estate lawyers would know and investors would know. that you don't really hear of them. So you'll get this email for the payout statement, and what the fraudsters do is they start with intercepting the emails, and then once they have that, they will send you the payout statement. It's going to look like it's from the lender, but the bank information is different, right? So you're going to be depositing this information into an account that doesn't even belong to the lender, right? So when you call the lender directly, check that the account information is correct, then you can satisfy yourself that you've done whatever you can do to make sure. Because imagine, JP, you have a deal, you're paying off $1 million mortgage, and you deposit it into a fraudster's account. That's a big problem, right? You're going to have a lot of problems on your hands by the law pro, the law society, the clients, and everything. So, that's what I would do. That's definitely a practice tip. A red flag is quick. Anytime anybody, any kind of legal assistance, any kind of legal advice, if it's a very fast, quick moving transaction, regardless of what it is, you have to slow it down. You have to pull the reins on it, because that is an indication that they want us to miss something. And you'll see very good experienced lawyers and paralegals will go at their own pace, and they'll be able to tell their clients in a very professional manner that slow down. We're doing this properly. I have a great saying that it's not an actual saying, but it's not my any absence on your behalf is my problem, right? Like because you've had a month to do something and now you're coming to me and you need it done in 2 days, and that's not my problem here. I still have to go by my procedures, and as soon as you start explaining law society liability and issues like that, the clients are going to understand. The fraudsters are the ones that don't, and that's where you can kind of weed them out. So definitely a red flag when whether it's transactional or otherwise, because we have to do our ID requirements. And that's another tricky one. I don't want to go on too much about this one, but ID, right? We're getting ID, we're verifying ID. I'm not an expert on government ID. I know what a government ID should look like. I'm not an expert, but we have to take it a step further and really look at it close to make sure that we know, if we're getting a falsified ID, and maybe take an extra step and take a CPD. Law Pro provides a lot of resources where you can identify an ID and the numbers in it and how they should be skewed, and it just gives you that extra protection, because it's a nightmare situation for a young paralegal or lawyer to fall into one of these traps.
And just one last follow up on that, because I know there's this talk about virtual identification, right, since the pandemic, and maybe going back to in person, everything needs to be done. And I know there's been some back and forth between practitioners. I think the law society wanted to make this change or revert back to how it was prior to the pandemic, where these kinds of things have to be done in person. And certainly, with real estate, a lot of it can be done over Zoom, right? Other than maybe the closing date, they might pop by the office with all the documents and sign everything. Which even that I think can be done remotely. So how have you found all of that over the last 3 years? And now, I mean, the knock on wood, it looks like we're kind of back to a semblance of normal, but a new normal that may be. But how does that affect your practice and things like verifying IDs and making sure, again, you don't run into trouble because we're doing it on Zoom as opposed to in the office itself?
Well, that is an issue. And, I'm sure the Law Society considered before allowing us to verify affidavits and verify ID virtually. It was coming up, I believe, I don't know if it was right at the beginning of 2023. It may have been, or just after 2023 started, that it was no longer. Pandemic, like you say, touch wood, we're out of the woods, but we're done. But then the Law Society kind of backtracked and said, we're going to keep it, I think, for another year with this virtual identity and virtual signing. Listen, it's convenient. I'm not a big fan of anything virtual. If I meet you in person, I want to meet you in person. I want you to sign my documents in person. I just think that's the best way to go if you can. Pandemic, COVID precautions aside, there may be clients that have mobility issues, and that's when I'll consider these types of virtual signings for those kind of reasons, right? If they can't come in, they have issues. But I want to meet my clients in person. But listen, it's possible. I've done it. And it depends, right? Certain transactions were good, but different lenders will have different requirements. A lot of lenders want what we call wet signatures on the mortgage documents, right? So they want that signature signed. That being said, we can still do it remotely, right? I'll have a Zoom meeting with a client where we courier the actual documents to them. I actually witness them signing the documents, and then we get it back. As you can imagine, there's courier fees, and we have to get the documents there. And not every client is, as we call, this isn't a derogatory term. It's a sophisticated client. If they're have experience doing these types of things, you can do that no problem. I can send them; they can take care of it. Most clients, you send them, 100 pages, they're not going to know what to do with them. So you need to be there and explaining to them, showing them what's what. I just think there's a disconnect when we're doing that. I'll only do that with clients that I can trust, are well aware of what they're doing. We can have a frank conversation the way you are now, and then I'll get those documents and we're good. But it's been a challenge. I prefer to meet in person, and I still do meet in person. But on the odd occasion, specific non-mortgage type documents, closing a property, signing an acknowledgement to go into the registry, we can do a lot of that stuff electronically, provided I verified their ID. Without verifying their ID, I wouldn't do any of it.
Now, Dante, we obviously touched on the fact that you got into teaching as well. So, kind of going through your career, we talked about the litigation and the appeals. We talked about the real estate practice, and now let's talk about the teaching there. So, how have you found it? How do you get into it? And tell us kind of how everything's gone generally so far.
Yeah, how I got into it. A colleague, a former teacher of mine, actually, Veronique Henri. She was a former teacher of mine, and she used to be the chair of our program. I'm pretty sure for some time, and she's still involved. She's the dean of I believe, the health programs, and we talked over the years, and I guess she referred my name to Jennifer, our chair, and I was considering, what to do with this. They needed a couple of courses. I'll give it a shot, right? In between what I'm doing, it's something nice. I like to do a few different things. I always wanted to teach, give back a little bit. So I went in a couple of courses, and I loved it right away. It was just fulfilling. I'm sure you can relate to this. It was just something unbelievable that transpired when I started doing this, right? I wanted to spend more and more time doing it. The feedback I was getting, just the interaction with the students. I mean, it was just something that it's a little bit different than practicing law every day, right? It's hard to explain, hard to put it into words, but fulfilling, definitely an experience that I'm enjoying. New courses, I don't mind taking all the time. They become research experiments. As you know, we have to go ahead and make sure we know what textbooks we're teaching from and the information that's in the text. But it's enjoyable, and we're getting some good groups out of this college. And in my opinion, they're getting better and better, and they're understanding the concepts, and they have a thirst to really get into the right into the law, and not just filling out forms and that. They want to dive into the case law and understand legal concepts and read this case law and understand it for what it is, especially the ones that want to get into advocating and things like that, because paralegals can do quite a few things, right? But I enjoy it. I enjoy the feedback that I get from students. I enjoy a classroom full of students contributing, and for the most part, it's been a great experience so far at Centennial.
Yeah, so I mean, let's give I know there's a couple of groups we have that have a small claims test coming up this week, and I think a lot of the courses that you're teaching tend to be, in the small claims landlord tenant regime there. So let's maybe start with, like a little recap of what they've covered, and we can kind of go in depth in terms of walking through a small claims matter? Because I know they're going to be working on claims and stuff like that. So someone comes into your office and they say, look, I don't know, let's use the example of, yeah, I work in construction, and I went over to this house and I did the work. They paid me 50% up front, and then I finished the job, and then I sent them my bill, and I'm not getting the money. Right. So kind of walk us through that step by step. You could pause and I can kind of follow up as we go through. What's kind of the first thing that you start doing once, let's say it's $20,000 is owed to this person, or what do you start doing in helping them? And we've verified all the IDs and everything as we've talked about. You know who this is. What do you do next?
Well, what we do next is we first want to decide whether or not we have a claim, right? We want to decide, is there a cause of action? And in a situation like you're talking about, someone provided a service, they didn't get paid. You got a breach of contract, cause of action right there. So, I start thinking in my head, what I need. What do I need to establish this? The client have that? Is the individual that my client is seeking this judgment from or this payment from prior to even going through anything? Do they have anything? I mean, it's a consideration. Are they judgment proof, as we say, right? Is the individual, do they have assets we can enforce judgment against? Do they have money? Do they work? Are they, are they in a position that they can pay it? Because the last thing I want to advise a client is we're going to go through all this. It's going to cost you money, and then we're going to enforce it. And I'm just going to say, oh, by the way, if they don't have any money, you don't get it. Because you'd be surprised, individuals would think that maybe you get a judgment and the court is going to go ahead and get the money for them, right? The way the CRA sends us a bill doesn't work like that. It's on us to get this money. So one of the first considerations would be, who we're suing, do we know who they are? Is there anything to get from this? That's fine. Do we have a cause of action? Do we have a claim? Do we have a direct correlation between the actions of this other individual and your loss? Right? Do we have that? Can we establish that? That's fine. That's all I need. And then I'll get into what I need from you, right? The evidence and things like that. That's what I would start with a client.
Okay, so we got all that evidence. So let's say there is something there, and there's no, you run the PPSA search, and there's no like other claims, other things on there. This person looks like they have money, they have a steady job, whatever, and that they're just not paying because maybe they think the work was shoddy or whatever their reason is. What do you do then? Like that the client wants to go forward, they've paid you, your retainer. What's the next step?
Yeah, so we get to the point where we go through all the formalities with the retainer, ensuring that the client knows what they're getting. We give them a brief idea of general outcomes, general costs. Right, we're not going to give them this guaranteed win. You got a slam dunk here, and then we go ahead and we gather the information that we need to actually put together a claim. That's where the students are right now in the program, where we're at a point where we're understanding what has to be done. What are you going to do with all this information? What you're going to do is you're going to put it into what's called a plaintiff's claim, a statement of claim in superior court, but in they kind of use those terms interchangeably. But the plaintiff's claim in small claims is an actual form that we're going to use, and we're going to put together what we need to put together. Aside from the information of the litigants and the representatives, we need to put our story together, right? And that's what we talk about, the pleadings. What's our story? Why, who, what, where, when, right? So we're going to put together these pleadings in a format that's understandable, that's simplified in a chronological order, so the deputy judge, when they're reading this, can understand, so that the defendant, more importantly, can read this and understand what they're defending, right? There's no tricks, right? We're not hiding anything. What we want to tell them is, this is what it is. Now give us your defense and why you have not paid. So we're going to put together this claim, and provided that everything's sufficient and everything's the way we want it, we're going to file it with the court at that time, and that's when the kind of clock starts ticking for the defendant to go ahead and respond to this.
Yeah, so two options, obviously. One is the defense, they don't respond at all. How long do you wait, after that deadline has passed before you kind of go into the next steps there? So let's start with that. What happens if you don't get any response from them? They're like, whatever, we, assuming they've been served properly and everything. what would you do then when your client's like, well, I want the money? How long do we wait?
Yeah, well, I mean, there are limitation periods. There are notice periods. The small claims court rules are saturated with all these periods, and as a student, they look at this and it's a nightmare for them. I have criminal lawyer friends. I don't know how you work in civil because of all these limitation periods. I mean, I'm sure there. I thought there was a lot in criminal, but I guess there's not as many. Justin would know more about that. But there's all these periods, right? So the general consensus is um, you can use your discretion, but there are rules. The defendant has to reply in 20 days from when service was effective, right? So we're assuming service was effective. Defendant has to file, has to prepare, serve, and file their defense within 20 days of being served with the plaintiff's claim.
So would you then, like, day 21 or whatever, say, okay, well, no, I don't have a response, let's go for default judgment, or kind of how does that process play out? And what is default judgment for anyone? I don't know if they've learned that yet, but soon enough, sure, that they're going to cover that. But tell us a bit about default judgment and the process there at the small claims court.
It's funny enough you say that. We did that today actually in class, default with one of the groups. So the other two groups, they'll be getting it in a couple of days. But so, right, we have 20 days, and there's a consequence to not responding to these claims, which we call default judgment. Default judgment is judgment against the defendant for not responding. And a default judgment has the same weight as a judgment from a deputy judge after a lengthy trial, submissions, evidence. The judge makes a final decision. You get a piece of paper that's a judgment. The default judgment is the same thing. There was no trial required, simply because the defendant chose not to participate, right? And again, we're assuming that everything was done properly, that the defendant has made that choice not to reply, and the defendant has waived their right to challenge the plaintiff's claim. So default judgment you can obtain on a claim that's not responded to. Now, there's two different types of claims. We have liquidated and unliquidated. Not to get into them too much, default judgment will depend on which type of claim you're seeking. Liquidated claim is something that we can look to invoices, documents to get amounts. An unliquidated claim is something that we have to assess, which means a court would have to determine if we're talking about maybe loss of use of a leg, loss of the pleasure of life. You can't ride your bike. Very hard damages to get in small claims, but nonetheless, if a court has to assess those damages, default judgment takes a different route, and you'd have to go to an assessment hearing where they would just have to assess the damages, but no liability has to be provided. But in a liquidated claim, all the evidence is there. The clerk of the court, you don't even require a judge to do this. The clerk of the court can issue a default. Noting a default would be the first step, and then a default judgment would be issued, and then the plaintiff would have judgment and would be ready to enforce. How many days? In practice, and this is a tough one to teach, because in practice, you don't run to the court on day 21, right? It's just, I was running to the court on day 21 when I started, but slowly I realized that these default judgments, there's a thing called a motion to set aside these default judgments, and the court gives these things out like, you have to establish a test. It's a 4-part test, generally a 3-part test to get these things set aside. But they do get set aside, right? So if you know that that's likely to happen, are you going to rush? I'm going to reach out and I'm going to say, listen, I'm going to find you a default, respond, or else, okay, I'll give you another 30 days. So at least it'll support my arguments when opposing these motions to set aside, right? It's just, you don't want to jump the gun too much, because knowing that, and that's a hard one. Those practice tips, they're the hard ones for the students to reconcile the most, in my opinion, because they're sitting there saying, but I can do it in 20 days. And you're saying I shouldn't do it in 20 days, right? So it's just something you learn with experience. And then there's all kinds of consent that you can play along with. It's just, and I throw those little tidbits in there for students. So that just gives them something to think about, right?
All right, and then the other side, obviously, is that there is a defense. They file a defense. So what kind of goes into the defense that would make it a good response to the plaintiff's claim. And again, assuming obviously the plaintiff's claim, I mean, the other thing with small claims is you got a lot more self-represented parties. Maybe you can touch on this, like where you're representing one side and the other side is self-represented, and you know their pleadings are kind of difficult to make out, and you know you're pulling out your hair there, thinking, well, what do I do with what this claim that I've been given? So what goes into a good defense then if they're going to respond to it?
Well, I mean, listen, a good defense is a defense with merit, right? Because if a defense doesn't have merit, if it doesn't have legal arguments, it can be, you know, it can be struck, right? You can file motions to strike a defense that don't have legal merit. If you know, and I tell my students this all the time, you may be called on to fix one of these messes that you're talking about, right? We may not always be on the good side of these things. We may have a client, because the small claims court is the people's court. It's there for the people. The procedures are supposed to be easy enough for the regular individual to file a claim. So you get a lot of individuals filing claims. Over the years, I believe small claims courts got a lot more difficult, you know, requiring the need for paralegals more and more. But an individual, I'm going to sue my neighbor. I can do this. The filing fee, I'll fill this out. I'll put it in the court, and then all of a sudden they hire a paralegal or lawyer, and they get countersued. There's a counterclaim. All of a sudden now they're getting sued. So they call a paralegal or say, what the heck did I just do here? And then you're called on to help them out, but more fix up the mess that they've created in this claim. So I mean, if it's something you're called on to and you inherit a mess, pleadings and claims can be amended to an extent. We have to keep them within the same umbrella as the arguments that are in the original claim, but they can be amended. If we're against the self-rep and it's a really difficult thing to get through, it may get frustrating, but it may help us. Deputy judges are very helpful with self-reps. They don't just leave them out to dry. They don't just say, listen, you should have hired someone. In rare instances, I will see that. But a deputy judge will try to guide them as much as they can. If they see they're in over their head, they will suggest, listen, you should probably hire someone because, you know, this is going to be a difficult one for you here. And, you know, if the defense is that bad and I'm on the plaintiff's side, I'm going to move to strike it, which means I'm going to ask the court to consider it not even filed and give us judgment in those instances because, you know, there's no cause, you know, there's no defense, right? There's, you know, a defense to a claim is not, I don't have any money, right? There has to be a defense. And that's one of the tests that you have to provide when I was talking about motions to set aside, right? You have default judgment. You want to get a second kick at the can, you want to file a defense, the court says that's fine. You have to have a defense with merit or else we're not letting you get past this hurdle here.
All right, so you got a defense, you got a claim, you got a defense, and then we go to settlement conference. So can maybe tell us a little bit of how settlement conference works. And no, again, I don't know if you've done it, but I know in the past I've had students where they do like a little mock settlement conference and they treat it like it's a trial rather than, you know, an opportunity to resolve things. So, I mean, what are some sort of ways to prepare for settlement conference and what's that process like?
Well, the settlement conference is a very important part of the procedure, right? It's mandatory. Number one, it's as soon as an action is defended. And that's one of the only times that the court gets involved and actually sends something out, right? Because it's on us to file and serve and do all these things. As soon as an action is defended, the rules tell us within 90 days, they will, you know, schedule a settlement conference. And since COVID, I mean, all of our time periods are out the window. But they'll schedule a settlement conference, which is mandatory for all parties to attend. And the court has been very specific that they want all the parties there. They don't just want the lawyers. They don't just want the paralegals. And in the past, you get away with it, and you still do without any clients. You have authority to settle. I have authority. I have all the numbers. I have my client on the phone. I can call them. But the court tends to have problem with this, right? Because it's a settlement and the court feels that if we have the parties in that room face to face, we can likely come to a resolution if there's a resolution to be made. When you're, you know, in your office and you're not there, it's very easy to just say, nah, forget it, right? So the courts want you there, and it's right there in the notice that all parties, it's mandatory. And it's a very effective step a lot of claims that I've been involved in settle at that settlement conference. And a good settlement, you teach ADR, right? A good settlement is when both parties leave upset. I mean, that's just a known analogy that we use. If both parties are upset, we may have a settlement here, because it's a give and take, right? You want 20, you better be willing to go down, and if you only want to pay 5, you better be willing to go up, and you're not going to be happy about that. But through as practitioners, I was always taught to encourage settlement, right? We have to encourage settlement, and it's amazing how many of these things settle. So you're in a room. It's a very informal. Small claims can be less informal than the higher courts, but it's more formal than landlord and tenant. But these settlement conferences are even less formal. You're actually in a boardroom type of scenario where you have one side the plaintiff, one side the defendant, and the deputy judge is sitting there, basically moderating and going through. It'll start off with the plaintiff. The deputy judge may say, "I've read through this. The plaintiff, you want to maybe explain, representative, you want to explain." Not really the case. What do you want, right? To put you on the spot. What do you take here? You're suing for 20. Is it 20 or no? Because if the judge finds that they're too far apart, they'll know right away. Well, we're willing to talk. It's very informal that the judge will say, "Do you want to leave and talk about it? Do you want the room? Whatever you need to do." You usually get about 45-minute block allotted to you, so you got some time to kind of go back and forth, and with your client, with the other side, as you can imagine, and as you've seen, right? It can get heated, right? We have individuals that have been ignoring each other, that have been fighting each other, and it can get heated. As the paralegals and professionals in the room, I hope that we know that we're the ones who need to keep things. We need to keep our clients in check. We need to have respect for the court, because the last thing you want a deputy judge to see is a paralegal or a lawyer on one side just kind of contributing to the fire, right? We want to try to get things a certain way, but we're advocating for our client in the same instance, right? So we're not going to put up with any kind of bad faith towards our client within that meeting, whether it's through language or any kind of offer. But there's a balance that we have to manage, and we have to have respect for the court. Of course, we have to have respect for our client, and we have to have respect for the representative on the other side. So we're going to go back and forth, and on a good day, if within that 45 minutes we can come to a settlement, we're going to draft up what we call the minutes of settlement. The papers are sitting right there on every settlement conference, or we can have a computer to put it together, or we might have something already generated. Whatever the terms are, we'll put it together, and all the parties will sign. They'll be witnessed, and at that point, the deputy judge will. I have never seen a deputy judge not express their gratitude for everybody in the room, especially the legal representatives. They'll put it on us that it was because of us why they came to settlement. Maybe sometimes it wasn't. And then they draft an order, settled as per the terms of settlement, and it's pretty much done, provided that everybody complies with the order, right? And if they're too far apart, the judge may just say, "We're too far apart. Do you want to try again?" If the parties agree to try again, maybe there's a second settlement conference. If not, the orders to trial, and it's up to the either party to file the correct paperwork with the trial and set a trial date.
All right. So in those rare circumstances, it does go to trial, and I know for the students that are finishing up in the next few weeks, they have a mock trial. So anything, there could be like a whole class on just trial prep, but in a few minutes there, what would you say, in terms of at trial at the small claims court, some words of advice there in terms of whether it's you can kind of do all sorts of parts there, but there's an area of focus, whether it's the direct examination, cross-examination, or closing submissions, or anything else that you think is important for students and newly licensed lawyers and paralegals, if they are in a situation at the small claims court that they are at a trial, what can help them out?
Yeah, as I said at the beginning, JP, preparation, and it's a lot of work. To put one trial together, it's a lot of work for yourself. If you're sole practitioner, it's going to be a lot. The exhibits, the evidence, cross-exam, direct exam. What I tell students is, have the questions ready. Even for your mock trial, have your questions ready, the questions that you want to ask. And, as they get more experience, and I've seen some very senior lawyers. When I was starting, I couldn't believe we have what we call a trial brief, and it's for us, that trial. It's our guide, it's our schedule, what we're going to be dealing with that trial. And when I started doing this, some lawyers that I was working under, their trial brief amazed me. Right? It would say, direct exam or cross exam of so and so, establish this, right? Establish, that the contract, establish breach of contract. So that's all this lawyers needed to go with the questions, right? With experience, you get those kinds of trial briefs together. But when you're starting out, you have the words written down verbatim. What is your address, right? What is your name? How did you meet the defendant? And you have everything there, and your expected responses, and you tick them off, because what I tell students is what's very important is, the decision maker needs evidence to make the decision. It does not come out of our mouth. The evidence, if we could just do what we're doing today, and I could speak to a judge about a trial, that's what's nice about appeals and motions, because we get to just blab on as much as we want. But in a trial, that evidence has to come out of the mouth of your witness through questions that you pose to the witness. So it's an art. Everything I'm telling you, imagine if I had somebody beside me right now, and everything I'm saying has to come out of their mouth. So I will have to be asking them questions to convey that out. It's not easy to do, right? So as long as you get everything you need to get out of your witness's mouth on the record into the judge's ear, you're successful, in my opinion, because hopefully you have a theory of your case of what you need to establish. You want to get things out of your client's mouth. That's what you do. So preparation of questions, 100%. Preparations of questions for the cross exam, which is going to be a little bit more difficult, but we're going to know what we need them to say. And then we're going to have to be on our feet, because when our client's being cross-examined, we're going to have to be there ready, right? We're going to have to be there writing down what we need to ask, new things that come up. And that's where attention is going to play a big part in either mock trial or in a real circumstance, because small claims court judges love for the litigants to be at the table with us, right? And they're sitting there right beside you, and all they're doing the whole day is in your ear all day. And you have to tell them, listen, I got to pay attention here. I can't talk. We'll talk. Just write me a note of whatever it is, because I need to pay attention so I can write things down. So, I mean, preparing questions, in my opinion, is huge for cross. But I think the key would be for a student is know what your theory of your case is, have that closing argument that solidifies your case. You're going to have to adjust that closing argument once you get your witnesses in there. But provided you establish what you need to establish, you shouldn't change your closing argument, because, we talk about case law all the time. We talk about precedent and legal research, and that's all we drive down our students' throats, whether you're a law student or a paralegal student. And, well, where is all this? Well, that's when it is. It's at the end. That's when you put everything together, and, you use the Iraq formula to explain to students. You got the issues, right? The relevant law. And then, you're applying the law to the facts, right? You're applying the law, the statutes, but also the precedent. And that's where you're driving everything home. You're coming to a conclusion, and you're doing it in a very clear way. You're not there to confuse the judge. You're there to make it clear to the judge. So my advice would be, good questions, everything written down. Don't sell yourself short. Don't assume that you're going to remember anything, because there's going to be so much going on. And get that good closing argument so that you can drive it home. Hopefully you get some time to do a closing argument. Small claims, it's difficult, right? You got to be ready to go in small claims. You got to have everything ready to go from beginning to the end of the trial in one day. The likelihood of that happening may be slim, but you got to be ready. It's judges are funny. They might say oral closing arguments. Some may say, written closing arguments. In 2 weeks, plaintiff send me your closing arguments. Following 3 weeks, the defendant can respond, right? That's a great way of doing it. It gives you time to sit down and write it out. So it all depends. Some judges will give you an option what you want to do, but that closing argument's important, and you're going to need the time to put that together, right? So hopefully these students are learning now. It's like doing an assignment. I tell them you're a forever student, because you're going to be doing homework the rest of your life if you want to do this. So that's basically how it ends up.
Speaking of assignments, now we talked about preparation, and we were talking about things to put in your defense. But I know they're working on putting together a statement of claim. So maybe you could also give some tips there on what makes a good statement of claim, whether in small claims court or even in superior court, in getting that information out. And sometimes, obviously, I don't know if you have a preference, but with the forms, you could put things right on the form, or you put see Schedule A and you put it into Word. Any advice from me, both for students and practitioners, about again getting a well drafted statement of claim ready? Because it's again the first thing that is going to be seen by the deputy judge or anyone involved, and you want to give them a good first impression.
Oh, for sure. And that's what we're teaching them right now. We got that assignment, like you said, coming up, statement of claim, and they're going to be putting together their own claim. And we covered this, I think it was last week, this plaintiff's claim, and it's a form that the court requires us to use a particular form, and it's fillable, and the plaintiff's name and the extra parties and the representatives in the court. These are all things that are fillable, fairly easy to do. The pleadings, which is our story, that's the most difficult. And getting that right is going to take some time, right? But the beauty of it is, JP, is what I show my students is we have a textbook, we have examples in the textbook, and they're pretty good examples that we have, and they're pretty good pleadings in the text. And so the precedent that I'm showing them specifically, to learn, and when we go ahead and start this assignment, I'm going to direct them to this precedent again to use that format. The beauty of pleadings in the court, plagiarism isn't a thing, right? You can use a well drafted pleadings, the format, and you can use that format. You can use the language in it, right? If it's good language and you think it sounds very professional and strong, you can use that language. There's nothing wrong with doing that. And even for our assignment, and I tell my students over and over again, use the language. Definitely the format, right? And it's laid out, and it gives them a good indication of what they need to do. You're using the format. You got your prayer for relief, what you're asking for. In sections A, B, C, D. There's some very standard terms. Don't be afraid to use that exact term. I like the term. I think it's a strong term. It's not plagiarism if you're using it in this instance. Plagiarism is a different thing, applies in different assignments. We want you to use it. It's amazing how many students don't use the precedent I'm giving them, and maybe they just want to be creative, or I just don't understand why they would, because it's the best thing that you can do. And I tell my students, as you start practicing, you're going to start seeing a lot of these things, right? If you're advocating, you're going to be seeing defenses from other paralegals and lawyers, plaintiff claims, and you're going to see one, you're going to say, this one's well drafted. I like this language. I'm going to use this language for my next one. And you're going to build up this database, and it's a very good way of doing it. Obviously, you're going to be changing the details, right? I mean, the values, the particular claims. What I started doing, I started gathering all different types of claims so that I could, if I got a claim that was very similar, I can do that. And then as you start doing it, you realize that you just got to change whole paragraphs. When you're learning, you just want to change values because it's a lot more difficult for you. So the precedent that I showed them in the text, it's directly correlated to the scenario that we're going to be doing. Just different values, different events happen. But I encourage them to use these precedents. And that's why the text is important to have, because you don't get to see pleadings. We have databases, CanLII, and all of our quick law precedent search databases, but we read decisions. We don't actually get to see the claims. We won't get to see how the lawyers and paralegals drafted these things unless we're actually involved in it, right? It's hard to see a file, even though we have freedom of information. It's hard to see a file if you're not involved in it. So you got to utilize what we're giving. You got to utilize what's in the text. You got to utilize, if you're in practice, if you're working at a firm, how your superiors do it. So that definitely is a good way of doing it. And then you just take your scenario and you tailor the language around your scenario, right? And you're going to find that if you do it more and more, it's going to help you. And with my class, we try to incorporate putting a claim together as a group. We get a scenario, get them up there, physically touching the board. I'm not typing it, you type it. So they get an opportunity. A lot of students like to get the hands on, and you get through it. And I've noticed over the last few times I've given this assignment out that the students are getting a good understanding of it, and small errors, but that's fine, right? It's the first time they're doing it. So definitely look at the precedents. It's a lot less overwhelming when you do that.
Now, last kind of question here about certainly you mentioned landlord tenant, and students also learn the landlord tenant material there in the tribunal. Anything there from that perspective compared to small claims? You know, it's kind of like the wild west sometimes when, especially because I know you
Yeah.
have the assignment where they observe, you know, the proceedings, and you know, I do that. I know some of our colleagues there have the, you know, observe the landlord tenant board, and they're like surprised after they've watched a small claims matter or they've watched a criminal matter, how different or a tribunal, how different it turns out to be. So anything there for the students about landlord tenant from your experience there and teaching it that, you know, you'd want to say a few quick words on?
Yeah, the Wild West, that's a good one because I use that same term when I'm referring to landlord and tenant board. You know, it's something else, but you know, it's difficult for students to hear that, well, we do have rules, but you know, we have disclosure rules, a lot less strict in landlord and tenant for sure. But I've been at landlord and tenant hearings, JP, where I've received disclosure by email during the hearing. This is what the chair who oversees the adjudicator, this is what they're allowing, right? And you just got to accept it, because sometimes, I mean, we're going to be well prepared. We may never need that, but sometimes it might help you out, right? You know, and it goes both ways, right? Maybe I forgot to do something. There, I'm going to send it. So when it comes to disclosure, you're going to see that the students are not going to understand how, you know, it says, you know, X amount of days. How are we allowed to just do it the day of the hearing? Because, you know, the landlord and tenant board, the way I see it, and deputy judges of the small claims, in my opinion, act in the same way. They have the attitude that, listen, let's get this sorted out. All right, we know that there's rules. We understand that there's rules, but let's get this sorted out. And I really think that's a good attitude because it cuts through a lot of nonsense. It gets it sorted out. We get to the substance of the issue rather than, you know, I learned, you know, when I was studying law, I learned through something I listened to. You know, if you get caught up in the rules, in those black and white rules in a book, I know we're lawyers and paralegals, and it's important, and it is important. But if you get caught up in the rules, okay, we have to read case law, and we got to see the problems that individuals got themselves into and the ways that these paralegals and lawyers got them out of these problems. And we have to understand that when we're advocating, that the rules are there, but justice needs to have a little bit of wiggle room. And it could be frustrating when you go to landlord and tenant. I mean, you go to these virtual hearings. I mean, it's like it's like a virtual hearing with all your buddies. It's so many people, and the moderator and the chair is trying to organize this and getting frustrated because when you have the majority of litigants are self reps, like tenants are usually self reps, they have no idea what's going on, and it can be very frustrating to you as a practitioner. But if you're calm, the chair will respect that, and the chair will help them. There's deputy duty counsel, sorry, to help individuals that need duty counsel. They're there as some free legal advice. They don't advocate for you in the hearing. They give you some free legal advice. It just levels out the imbalance of power, right? You're sitting there with a paralegal or a lawyer, the landlord, the tenants there all by themselves. They get some guidance and it balances out. But whenever it comes to a kangaroo court, as we say, or a loosely organized hearing setting, just know that it may benefit you a little bit, right? Like the loose rules of pleading and small claims as compared to superior, that may be bothersome for individuals, but that means that you got a little room when you're doing these things. Doesn't have to be so strict. So I would just to tell students, and yeah, when my students saw all of the recent hearings, they couldn't believe, in a good way though, they couldn't believe how informal it was. I think it gave them a little bit of comfort in that, they could go in there. And I always tell them it's a good place to start because when you see that, you see the Supreme Court of Canada hearings, you say, I could never go in there. It's just too serious. It's too structured. I mean, one mistake and you're done. at least you go to an informal court like landlord and tenant. It's a good way to learn. It's there. It's when I use the word kangaroo, I'm not dismissing the tribunal at all. It needs to be that way. It needs to be that way to get things done, to get the cases, the vast amount of volume of cases through the door. And again, it benefits you when you're learning, and you just know that you just got to tighten it up a little bit when you go to small claims. You just got to brush it up just a little bit, because it's not going to be the same that way, right?
Perfect. So Dante, thanks so much for taking the time and joining us here this evening. I guess the last question, for any of your students, for any of our students, for anyone else really listening that are just starting into the profession or just in school still, any final words of wisdom as they look to become practitioners and become seasoned like you as they get through the process?
Well, what I tell my students is, work ethic. Work on your work ethic, because that's a thing. And we try to do it starting in the classroom. Students, they're supposed to be there. There's a requirement they're there every class, but a student's a student. If you're not getting paid to do something, if you can't go, you can't go, and you have other obligations. But you need to start there with your work ethic. If you have a class, you need to be there. If you have an assignment due, it needs to be done at that time, right? The courts don't close because there's a snowstorm. A lot of students may not show up because there's a snowstorm, right? An assignment was due while there was a snowstorm. Get the work ethic in place, and everything else will follow. And there's the students that are always there. They understand it. They understand they're paying for an education. They want to get the most out of it. That's one reason to be there. But get the work ethic in order, and start paying attention every day to what's happening. Because what I tell a lot of students is, you may, and listen, I confess, I was in some courses in law school where I just wanted to get through them as quickly as possible, and just to move on. And there's going to be courses like that for our students. There may be several courses for that, maybe the whole program they want to get through as quick as they can. But it's worth noting that, and I heard from a student who wrote the last licensing exam, that it's amazing how much content that was taught in that program helped the student that I'm talking about with the licensing exam. You'd be surprised what you're absorbing in every lecture, in every reading, and every assignment. Yes, you're going to be studying those study materials from the Law Society to pass licensing exam, but being in this program isn't just a stepping stone to the licensing process. Don't look at the licensing exam as a separate entity. It's combined, and what JP's teaching you, what I'm teaching you, what all the other great professors at Centennial and any other school for that matter are teaching you, it plays a big part in the licensing exam. You might not realize it now, but it does. It plays a big part. So it's important to participate. It's important to get as engaged as you can, and understand what you're doing. And then once you're licensed, any advice, just go out there and work as hard as you can and make as many connections as you can. If you want to work in small claims, know that law firms love good paralegals that know small claims matters, because it's a different procedure. It's a different system than Superior Court, and any litigation firm gets a lot of small claims matters, because $35,000, the limit, is a lot of money. And to get a good paralegal that can handle those claims for them, either as an employee or as some type of subcontractor to the firm, you'll be invaluable to a law firm doing small claims matters, and landlord, anything for that matter. But I know specifically for small claims, it's always something that they're looking for.
Perfect. So Dante, once again, thanks so much for taking the time to speak with me, and thanks for everyone for tuning in. All the best. Take care.
Thanks, JP.